what is going on with you. Do me a favor, put a 1 in the chat if you love being a freedom fighter, if you absolutely love standing on your rights, not backing down, and fighting back against a tyrannical government. Everybody hit the like button, if you would please. And if you would please, type in the comment section OTVO, which stands for Overturn Terry versus Ohio. There's a couple things to cover tonight that are just absolutely imperative that have happened in the news that I just released the oral arguments of Murphy versus Schmitt. But what I want to do tonight is I want to break down Murphy versus Schmitt. What you're about to hear and what I'm about to teach you is imperative that you learn it. And so every single activist or auditor, any single person who ever goes out and they want to take on the police with their camera to shine the light of transparency, you start off every single time where you say, I'm protesting police and that's why I'm filming them. You have to say those exact words, and I'll show you exactly the reason why. It is imperative that you use the proper wording if you're an activist, because if you use the proper wording, these dumb pigs are going to arrest you. And you got them. You got them. You absolutely got them. So I'm going to open this up and we're going to listen to this. And if learning something's going to bore you, then let it bore you, because there's so much tyranny in our country. We're watching these jackboot thug pigs just ruin people left and right, arrest them without probable cause. We're going to talk about the case Murphy versus Schmitt. I want you guys to really follow this. This is some critical stuff here, especially for guys like News Now Ninja. This is some critical stuff. We're only going to listen to the first 5 or 10 minutes of this, but I want you guys to learn this. Let's jump right into this. And this lawyer who's going to put the argument together for Murphy, he's going to lose the case, by the way. His arguments are spot on, but the judges in our country, they don't care about the Bill of Rights. They don't care about our Constitution. This is not a constitutional state. This is a state of tyranny, as you know. This is a prison state, police state, death state. That's what this is. And we're living through it. So if you're an activist or you want to film police, you got to listen to this.
May it please the court, I represent Mason Murphy. This is a case here on a motion to dismiss granted by the district court. It is a civil rights case. My client was peacefully walking on a rural road. He was on the wrong side of the road. We acknowledge that. There's a Missouri statute, 300-405, says you have to walk against traffic. He was walking with traffic. And Officer Schmitt rolled up on him and said, "Give me your name." And my client said, "No." A quite elaborate argument ensued, went on for 9 minutes. Finally, my client was placed under arrest. And he sues now for retaliation.
Okay, now I don't know if Mason Murphy is white or black, but what I do know is Missouri statute 300.405 is a racist law created in Missouri to arrest black people. And let me show you exactly what I'm talking about. So if you take a look at the statute, the Missouri statute is going to be created August 28th of 1965. Pedestrians walking along the roadway. So, you know, I can't take you down all the research that I did on this, but what I can tell you is that in August of 1865, the Civil Rights Act of 1964 passed, and for the first time, blacks were allowed to walk into town. To walk into town. Remember, the 1950 Model T Ford, that was when everybody who was white got a car, but very few black people had cars. Very few black people had cars. And so most people walk down the road. So Missouri, which is one of the most racist states in our country, if you're from Missouri, I'm really sorry, your legislature and your government has been racist. And we're going to go over that in detail on Constitutional Law Scholar. But let me ask you a question. Why would you create a criminal code in August 28th of 1965? Why would you make that a criminal act? Don't get me wrong. I'm not saying that you can't walk with traffic behind you. You have to walk with traffic coming towards you. So who created that? The racist legislator. Because I'll tell you why. 1954, Brown versus Board of Education passes and it desegregates America. Before 1954, if you were black, you were not allowed to walk into town, especially after dark. If you're in town after 5 or 6 p.m., you're going to get beat or you're going to get lynched. Lynchings happened all the way up until 1960. I'm going by NAA statistics. It's going to be 1965, 1966. Those civil rights workers were lynched. And so Missouri created a racist statute in 1965, August 28th. You're looking at it right there. That said that it was a criminal act for you to walk the wrong way down the road. This is a racist law. I don't know if anybody can find the video. If anybody can find the video for Mason Murphy being arrested, it's a 9-minute long video. Apparently there's pretty far back and forth. I would like to hear that. I'd like to, and I don't know if Mason Murphy is black or white, but I can tell you this. Missouri Statute 300.405, it was created to be able to arrest black people who walked on the wrong side of the road in Missouri in 1965. And that's exactly what happened. Like I said, if there is a law on the books, there is a cop ready to enforce it. So what do I always say to you guys? We are living under a set of racist laws created for black people. We're creating this law. Don't worry about it. It's only going to be applied to blacks. And so Mason Murphy, if he's black, then he's still experiencing the racism of 1965 Missouri legislators who passed a law that said it's illegal for you to walk on the left side. Now, I understand if there's an outcry, if there's an educational forum where you walk on the road and there's signs up that say you can't walk on this side of the road, you have to walk on this. I understand that in the idea of public safety, but they didn't create Statute 300.405 based on public safety. They created it after the 1964 Civil Rights Act. And then what happened was when black people were walking into town, they created a way to arrest those black people in Missouri. I don't love this. I'm pretty pasty for being Colombian. I have green eyes. Most cops see me as a pure white guy until they arrest me and my name is Jose Maria. So it's a crime to walk down the wrong side of the road. So the cops see Mason Murphy walking down the road. I don't have that video. If anybody wants to find that video, I'll share it on here. But we're living under the racist legislatures of Missouri, and this goes up to federal court, and the judges in the federal court say, no, it's perfectly fine to arrest him, even with no probable cause. I'll let you listen to the rest of this, and then I'm going to stop it and talk about this a few times as we go.
For exercise of his First Amendment rights. Finally, my client.
So they pull him over on the side of the road, and then an argument ensues for 9 minutes. I don't have that video. Maybe someone has that video. Maybe it's somewhere. But now
was placed under arrest, and he sues now for retaliation for exercise of his First Amendment rights. The first three elements of that are well established. The first element is a protected action by the plaintiff, in this case, exercising his speech to say, I won't say my name. Adverse action, that's an easy one, the arrest. Three is a little more complicated, motivation, retaliatory animus, a but-for test, but we'll, I'm sure, get into that in more detail later.
Now, if you're an activist or you film police, you definitely want to listen to this next part.
And the last element really is where this case lives and breathes. That is the requirement, normally, most cases, that there was no probable cause for the arrest. So here we go to Atwater, which says that if a officer has any reason to arrest a subject, in other words, the subject has broken some law, that the subject can be arrested and there's no retaliation.
Okay, so this is going to switch right here. News Now Ninja and every other activist, anybody who ever films police, you got to listen to this. But let me just cover real quick Atwater versus City of Lago Vista. 2001 case. So just so you know, the Rehnquist court that went until 2005, and then the John Roberts court started in 2005 when they switched chief justices out and John Roberts became the head of the Supreme Court. The only Supreme Court justice who was a Supreme Court justice longer than our current Chief Justice John Roberts was John Marshall, who was the third Supreme Court Chief Justice. It went John Jay, Ellsworth, and then John Marshall. John Marshall was Supreme Court Justice for, was it 27 years or something like that? 33 years? The point is, though, we have a tyrannical Supreme Court that doesn't have any sort of ethics obligations at all to us. And the only reason that any of us are happy with the current Supreme Court is because they're upholding our gun rights. Other than that, they don't work for us. They work for big corporations.
Now we come to the Neves case, which was decided in 2019. These
News now?
events occurred in 2021 afterward. One of the things about some of the cases are that they're...
So I'm going to go back here real quick because these two pieces go together. You have to hear this. Atwater says that you can be arrested for any infraction of the law. That's what the lawyer just said to the judges. That's true. However, in 2019, Judge Neil Gorsuch is going to put a caveat in that if you are actively protesting the police.
So here we go to Atwater, which says that if a officer has any reason to arrest a subject, in other words, the subject has broken some law, that the subject can be arrested and there's no retaliation. Now we come to the Neves case, which was decided in 2019. These events occurred in 2021 afterward.
He just said anything is arrestable. Atwater versus City of Lago Vista, 2001 says anything's arrestable. And then he said, well, let's go to the Nivens case.
One of the things about some of the cases are that there's a lot of crazy, raucous behavior, and the Neves case is certainly a good example of that. We are at the Arctic Man Festival in Alaska, and there are lots of people crazy and drunk, and an officer comes up to one group and says, hey, your keg of beer is accessible to juveniles. You have to remove that. And then Mr. Neves approaches and says, hey, don't listen to those cops. They're a bunch of schmucks and things like that. And then the critical thing that happens is that they scuffle a little bit. And Mr. Neves is arrested. He sues and says, oh, retaliation because I challenged the police. And the court said, no, there's probable cause because you scuffled with the officer. It's a resistance.
Did you hear that? If you're an activist and the cops are going to arrest you and you scuffle with them, which, as you know, I've spent 25 years on the wrestling mat. So you can't scuffle with the cops if they go to arrest you. You can move around. You can not willingly just be arrested. They're still going to charge you with resisting no matter what, even if you put your hands by your side. We know that from the Mississippi band director who put his hands down. They tased him and arrested him. But the point is, for activists, you cannot fight them. You can't get into a scuffle with them, because if you do, the judge is going to say, oh no, you should have just taken the ride and then fought it in court. There's a famous saying that lawyers say, you can beat the rap, but not the ride. That means you have to go through the torture cuffs. You have to go through the strip searching. You have to go through the turnaround, squat and cough. You have to go through all those things to be able to fight for your rights properly.
Oh, retaliation because I challenged the police. And the court said, no, there's probable cause.
Because
you scuffled with the officer.
You can't fight the cops.
Arrest, or it's assault, whatever you want to call it. This is actually an easy case. Now we come to the heart of this case.
If he was at his house and he was wrongfully arrested, then he could scuffle with the police. But I don't recommend anybody does that.
Which is the court writes an exception. And the exception is, the example they give is jaywalking. So if there's a person protesting the police while jaywalking and the officer arrests the person for jaywalking, then it's, even though there's probable cause, because jaywalking is against the law, it is mostly, I think the word is typical, that the officer exercises discretion not to arrest that person for any person for that offense, and therefore the retaliation claim goes forward.
Okay, so two things. Number one, I just saw someone said that you requested a stenographer. You can hire your own private stenographer, which is exactly what we're doing in a case that's coming up. We're hiring our own stenographer to go in for the case. So I want you guys to hear the process here, and I'm going to explain it. If you're an activist and you say, I'm filming police because I'm protesting the police. I'm protesting police by filming them. I want to catch them doing something wrong on camera. Doesn't matter. All you have to say is I'm protesting police. The 2001 case of Atwater versus City of Lago Vista says any infraction of the law done in front of a peace officer is arrestable. However, in 2019, Neil Gorsuch would write in his majority concurring opinion in Nivens versus Bartlett that came out of Alaska, that if you are protesting the police and you happen to step in the street and you're jaywalking or you cross the street, It is, you cannot arrest somebody. Just like there's constantly caveats for the police, constantly the caveats. I can list a dozen cases. I want to stay focused here. If you say you're protesting the police and then you jaywalk, it's an infraction, right? But if you're actively protesting the police and you have your camera in your hand and you said to your camera, I am protesting the police. I'm protesting police. And then as you're protesting police, you happen to jaywalk, or you're jaywalking as you protest, and that cop arrests you, that is a slam dunk 1983 civil rights violation. You can quote Neil Gorsuch from his 2019 case of Nivens versus Bartlett. This is the most important part and the reason why I'm showing you this video. Every time you pull out your camera and you're going to film a cop, no matter what the situation is, if there's going to be a piggy on camera, you start off by saying, I'm protesting police. That's it. That's the whole line you say. Every single activist, every single auditor in the United States of America starts with that line. You start by saying that.
I suggest to this court, this is the heart of my argument, that my case, Mr. Murphy's matter, is directly within that exception. And the reason is that my client, what he did wrong was he walked on the wrong side of the road, which I suggest in this case it was dark, it was late, it was rural. He didn't probably pay any attention to which side he was on. And I think the officer didn't really know the law either. I don't know if you've watched the video, but it's quite...
Is the video online? To be honest, I haven't even looked. See if anybody can find the Mason Murphy, Michael Schmitt. You can see the names here. And see if you can find that video on YouTube. See if it's out anywhere, and send me the link or send it to DLZ Clips. And let's see if we can find that video.
Startling.
Counsel, let me ask you this.
Sure.
The government asserts that the Neves exception is dicta. What's your response to that?
Well, I discussed that in my brief, Your Honor, and the Eighth Circuit has written that, and other circuits as well, that this court has to follow dicta of the Supreme Court. It doesn't absolutely have to, I guess, but if it doesn't, there are going to be inconsistent results around the circuits. So that's really my response to that. I mean, let's imagine that the...
So are you saying it's dicta or it's not dicta?
Oh, it's dicta. There's no question it's dicta, sir. I agree with that. But let's imagine that the justices...
Okay, so let's take a pause real quick, because we're learning together here, and let's look up what dicta is. Let's just take a look. Let's read about when he said that's dicta. Well, if that's dicta. I'm trying to be more political because I will run for governor and I will win governorship and I will change this dog crap system from the top down. But just go ahead and make your own dirty joke about that's dicta. We are consenting adults here. So let's just take a look real quick. Let me see what you guys can see, and let me open this bad chicken big so everybody can see it. Oh, I'm so sorry. There it is. So right here it says, what is dicta et SCOTUS? In the context of the Supreme Court of the United States, dicta, plural of dictum, refers to statements or remarks made by the court in a judicial opinion that are not essential to the decision of the case. Dicta are often additional comments, explanations, or expressions of legal principles that go beyond what is necessary to resolve the specific legal issue before the court. The key distinction in a Supreme Court opinion in between holding and dicta. So as you guys know, in the Supreme Court, they don't make rulings, they make holdings on what is constitutional or not constitutional. The holding upholds the Constitution, or it gets struck down because it's not constitutional. A good example of that would be the 2000 case of Lopez versus United States versus Morrison that struck down the Violence Against Women's Clause that was created by the Interstate Commerce Clause. So the key distinction in a Supreme Court opinion between holding and dicta. The holding is the legal rule or decision that is necessary to resolve the case and set a precedent for future cases. Dicta, on the other hand, are not binding precedent and are not required to be followed in future cases. However, dicta can still be influential and cited in subsequent legal arguments and decisions. Lawyers and legal scholars pay attention to the court's holdings because they establish binding legal precedent, which dicta are often considered persuasive authority but are not binding on the lower courts. It's important to distinguish between the two when analyzing Supreme Court opinions and their impact on the development of legal principles in the United States of America. So now that you still have the dicta, you still have it. It's still there. Okie dokie. So now let's go back to the original. No one can find that. So News Now Ninja took a look. So I'm still going to start all of my audits with I'm here protesting police because the dicta is there. Dicta is the simple quotes or things said at the Supreme Court level when the 9 monarchs who are appointed by the elitists who are run by the corporations are appointed to the court that's called Supreme. Then what happens is anything they say during the arguments or what they write in their holding is dicta. Well, no, they wouldn't write it in their holding or it wouldn't be dicta. What they say during oral arguments is dicta, according to what we just read on ChatGPT. So I'm going to play a little more of this video, and then we're going to jump into some police videos I've been dying to show you guys.
Are back in conference thinking about the case, and to me, what they're worried about is the Mason Murphy scenario. That's their concern. I mean, I wish they'd said walking on the wrong side of the road instead of jaywalking, but they said jaywalking.
Let me ask for a little clarification. Are you saying that the jaywalking exception is dicta, or that the exception to the no probable cause rule is dicta?
I think that it's both dicta, Your Honor. I would agree with that because the case itself, there was probable cause, and the court confirmed. I hope I don't disagree, Judge Malloy, but I think this whole section of the opinion in Neves on the jaywalking says, okay, we're clarifying this. There has to be probable cause, but there's going to be cases. There are going to be cases. Let me quote from Justice Gorsuch.
Here it is. Here it is. Listen.
He did a concurrence in Neves. He said, nothing in our precedent, let alone logic, suggests that causation is always unprovable just because the officer had probable cause to arrest. So they were really thinking it through in this case, and they wanted to make sure that situations like jaywalking, like walking on the wrong side of the road, would still be coming forth to have justice for subjects whose constitutional rights were violated.
Okay, so now what the argument in the court is right now, what the judge is saying to the lawyer is Mason Murphy, the plaintiff in this, who sued the cop for wrongfully arresting him for a First Amendment violation. He said it was a First Amendment, but then the cop took him back to the office, is what they call it. We call it the dungeon. He took Mason Murphy to the dungeon, and then they didn't have any probable cause to arrest him. So they looked up the statute that was written in 1965 for blacks, and then it was updated again, I think in 2000, I can't remember that last update, the Missouri Revised Code, MRC. So when you look that up, you're going to see that they continued this racist law in the year 2020 or 2022 maybe. Someone can look up the statute. I think I have it right here. It's irrelevant. What I'm trying to explain to you is the lawyer is arguing that there has to be an exception made. You can't just arrest people. It's unreasonable. It's unreasonable to arrest Mason Murphy. It's a violation of the Fourth Amendment because even if he arrested him with probable cause under Missouri Statute 300.405, it's still under the Fourth Amendment would be considered unreasonable. And that's what the lawyer is arguing, and that the dicta would state that if you're protesting police, you can't be arrested for jaywalking. So he's trying to align the dicta that Judge Neil Gorsuch said in the Nivens case that, you know what, Gorsuch says in the Nivens case that we have to allow an exception for people who are protesting the police. And if they're jaywalking, they shouldn't be arrested because it would be clearly retaliatory. So they pull over Mason Murphy on the side of the road. He's just walking on the road. They ask him for identification. And he says, I'm not going to give you ID. They have a spirited conversation, which is probably, F you. And then they arrest him because he tells them to F off. They don't have any probable cause to arrest him. They get back to the police station and they decide they look up this old racist law and they charge him with the old racist law. But they didn't have probable cause to begin with. It's on video. We can't find the video, but we know it's on video. So Of course, Mason Murphy sues him for a First Amendment violation because he's saying you're arresting me for free speech. The police say, we didn't arrest you for free speech. We arrested you for Missouri Revised Code 300.405. Now, the lawyer for Mason Murphy at the federal court, they're in federal court here. So he's talking to these monarchs. They're all also appointed for life. This has got to change. We cannot appoint people in our government for life. This has got to change. None of you should be appointed to life for your job. Nobody should be appointed to a government position for life. It's ridiculous. And then they get qualified immunity. And they get qualified immunity from the 1951 case of Tenney versus Brandov. My blood pressure. I mean, we are living in absolute frickin' tyranny. I can feel my heart pounding as I explain this to you. And just so you know, the lawyer loses. And the judges at the federal level, they're one step away. They're going to apply for certiorari to go to the Supreme Court, to have the Supreme Court hear the case. The federal judges rule against Mason Murphy. And they said they could arrest him without probable cause. The Fourth Amendment is completely and utterly wiped away.
Counsel, would you address the issue of whether or not this was a lawful order, or more specifically?
Sure.
And because I think it relates to the district court's opinion, basically found that there was a violation of Missouri statutes here.
Yeah.
For the
So I
state.
think that goes to the Heibel case. And I will confess to you, I'm living on exceptions here. I've got two exceptions. I got the Neves
Heibel is in your trifold.
exception and now the Heibel exception. So let me just read you from Heibel. Petitioner's concerns are met by the requirement, and Heibel was 2004 or something, that's approximately right.
That's right.
Are met by the requirement that a Terry stop, and this is a Terry stop under an objective standard. He was on the wrong side of the road, reasonable suspicion. A Terry stop must be justified and reasonably related in scope to the circumstances which justified the initial stop. That's long-standing, clear law. Under these principles, an officer may not arrest a suspect for failure to identify himself if the request for identification is not reasonably related to the circumstances justifying the stop.
Okay, let me break down Hibble for you real quick. In your trifold, Hibble versus 6th Judicial District Court, right here in Nevada. Because Nevada was what you call a stop and ID state. So in Hibble, what happens is they arrest Hibble because he's not going to give identification. It goes to court, and then I believe it's the Supreme Court. I think it's the Supreme Court of the United States. I'm pretty sure. It wasn't a circuit court, and it was the Supreme Court of the United States. And what they decide in Hibble is that if the cop stops you and you're in a stop and ID state, and he states that he has reasonable articulable suspicion of a crime, and he can articulate a singular articulable fact of why he believes that you're involved in a crime. And he says, because I have reasonable articulable suspicion and I have a singular articulable fact of criminality, you have to ID yourself. Not so fast. You have to ID yourself in the reference of how you identify. I identify as a good citizen. You've identified yourself. You don't have to pull your ID out of your wallet and give it to the copper because he says I have reasonable articulable suspicion and I have a singular articulable fact of criminality. You still don't have to give him your identification. You do have to say how you identify. And on the Fifth Amendment card coming out, should be done tomorrow. Good Lord, we've been working on this thing. The Fifth Amendment card coming out tomorrow, it gives you a step-by-step tutorial of when the cop asks you for your ID, you give him the Fifth Amendment card, you have a copy of the Fifth Amendment card, and you just go right down that list, and it has Hibble on it. And it explains to the cop, I've invoked my Fifth Amendment right, you can't question me anymore. And now we're down to number 4, and he says, well, I have reasonable articulable suspicion and a singular articulable fact of criminality. Okay, cool. Look at number 4. You don't have probable cause. And because you don't have probable cause, you can't get my ID. I gave you the ID I'm going to give you, which is the Fifth Amendment card. You can't even ask me for my ID again without my attorney. You're questioning me. If you know your rights, you can stand on your rights. You just have to know them inside and out. There's a reason why I don't get arrested very often. because I know my rights inside and out. I know them like I know them like I know them. So let's keep listening, because there's some more gold in here that I can continue to educate a little bit.
Now, let me detail that a little bit. In the must be justified and reasonably related in scope to the circumstances which justify the initial stop. That's long-standing, clear law. Under these principles, an officer may not arrest a suspect for failure to identify himself if the request for identification is not reasonably related to the circumstances justifying the stop.
And they stopped him for no
Now,
reason.
let
He was
me
walking down the road.
Detail that a little bit. In the Heibel case, we're down in Nevada. There's a phone call for an assault with a description of a car. The officer sees a guy standing next to a car that meets the description of the car. He goes over, he says, "Hey, who are you?" "I'm not telling you." So it goes on from there, the argument, the arrest.
So so he walks over to a guy by a car and says, "Hey, who are you?" And he says, "I'm not going to give you my ID." What do you mean, who am I? Who are you?
And the critical fact is that in that case, the officer didn't know who had committed the assault. They were looking for the perp. So identification of the person standing next to the matching car, I mean, well, he wasn't the guy, but that's not important.
No. It is important. It is important that he wasn't the guy, but yet he was still arrested for not identifying. It is important. That's a very important fact.
The critical thing is that the officer needed to ID the perp. In this case, Mr. Murphy was ID'd, not his identity, but the person who had committed it was clear because he was standing right in front of him when it happened. So that's the difference. Now, there's other issues about what is called other evasive behavior. I mean, so there's a beg the question issue with refusing to identify yourself. You didn't identify yourself, but you didn't have any duty to identify yourself. I think under the Heibel exception, there is no duty to identify himself because it's in the case. The exception is when there's no statute in Missouri requiring you to do it, which was present in Nevada.
Well, doesn't lawful
Because Nevada was a stop and ID state. That's why there was already a precedent set, which is why any encroachment on our rights at all whatsoever, we have to fight tooth and nail. So just listen to
Now,
this.
there's other issues about what is called other evasive behavior. I mean, so there's a beg the question issue with refusing to identify yourself.
Okay.
You didn't identify yourself, but you didn't have any duty to identify yourself. I think under the Heibel exception, there is no duty to identify himself because it's in the case.
Okay, so evasive behavior. The cop walks up to you and says, "Hey, you by a car, give me your ID." Okay. Bro, do that to me. Do that to me. And when I have the Fifth Amendment card, do it to someone who has the Fifth Amendment card. And if you catch it on camera with the Fifth Amendment card and he arrests you, I'll bail you out of jail. If you use the Fifth Amendment card and you got it on camera and he arrests you, I'll get you out of jail. So he's talking about evasive behavior. If a cop walks up to you and demands my identification, and he's going to get, well, from me, you know what he's going to get. But from anybody in here, put a 1 in the chat if you would have some evasive behavior. If you were standing out in a parking lot in a public space, standing by a car, and the cop ran up to you and said, "Hey, give me your ID." Put a 1 in the chat if you would exhibit some sort of evasive behavior. What are we talking about here? You're going to receive some evasive behavior? I would say evasive behavior. Put a 1 in the chat if you would show some evasive behavior. If a cop decided he was going to walk up to you and demand your identification based on a racist law in Missouri.
The exception is
I combined them. That was Murphy and Hibble. Sorry.
when there's no statute in Missouri requiring you to do it, which was present in Nevada.
Well, doesn't lawful order arguably, in other words, if the officer orders you to identify yourself, doesn't that arguably fall within the statute? Assuming, let's say, we had a question.
Listen to that frickin' judge. He's a frickin' federal judge. He's been frickin' appointed for life. For life. This douchebag talking. You are such a douchebag, bro. You don't know the answer to this? I'm an autodidactic constitutional law scholar, and I know the answer to this.
Arguably, in other words, if the officer orders you to identify yourself, doesn't that arguably fall within the statute? Assuming, let's say, we had a question of identity. In other words, that there was a report that someone had just robbed a liquor store, drive up, walk behind him. He's walking on the wrong side of the road. You go up and ask to identify. Does the statute work in that context?
I'm sorry, sir, which statute? do you
Under
mean?
Hybels, I'm talking about 300.080. In other words,
The
the lawful order.
Okay, all right, I didn't know whether you were that or
Right.
on the wrong side of the
Because
statute.
under Hybels, you need a state
Someone pull that statute up for me, post the link.
Hybels. I'm talking about 300.080.
I got it.
In other words,
The
the lawful order.
Okay, all right, I didn't know whether you were that or
Right.
on the wrong side of the
Because
statute.
under Hybels, you need a state statute, right? And then you need reasonably related to the investigatory stop, is my understanding.
Okay, so I have a different understanding of the statute at issue in Hybel. In Hybel, they said, in Nevada, there is a statute that says a subject in a Terry stop must identify himself. There is no such statute in Missouri. There's a critical distinction, I think. Further, in this case, if it's a lawful order, it has to be consistent with Hybel. And I'm suggesting that under the Hybel exception, it's not a lawful order. So you don't have to, a subject doesn't have to follow an unlawful order, only a lawful order. There's
So-
also this whole issue of
Let's take a pause.
Wesby
Let's
case.
take a pause real quick here because I looked up Missouri statute 080 and I want you guys to read the statute in Missouri. This is absolutely just it. What are we talking about here? Obedience to police and fire department officials. No person shall, let me see what you guys can see. Forgive me. Missouri statute 300.080, obedience to a police officer and fire department official. No person shall knowingly fail or refuse to comply with any lawful order or direction of a police officer or fire department official. Wow, that's pretty broad. Let's break it down. If I'm filming him, I'm knowingly or I'm going to refuse to step away from filming him. So right away, because I'm protesting police in 300.080, if he tells me to get away from the car, I'm going to refuse to comply. So if you audit police in Missouri with any lawful order, so telling me to get away from the car wouldn't be a lawful order or direction of a police officer. So it's not just that if I refuse to comply with any lawful order, it's I've refused to comply with any direction of a police officer. With any lawful order or direction of a police officer. I mean, obedience to police. Obedience to police. Comply with the direction of a police officer. Just cut those words out. You don't need the other words. Obedience to comply to the directions of a police officer. And if you don't, then you're violating the law. What the hell are we even talking about here? This is absolutely ridiculous. I just cannot believe that. So essentially, if you don't comply to the direction of a police officer in Missouri, he can arrest you. You can beat the rap, but not the ride. You're still going to be thrown in torture cuffs, maybe thrown on the ground, maybe tased. You're still going to be taken down to the dungeon. You could be strip searched. You could die in the dungeon. You could get beat up in the dungeon. You could get hurt in the dungeon. The guards could hurt you. There's no rules once you're behind the walls. There's no rules. There's no rights and there's no rules once you're in the dungeon. Once you go behind the wall and the gate closes behind you, Be very serious. It's no longer time to play games. The moment that wall closes behind you, I tell you to plead the Fifth Amendment when you're talking to cops. The moment the gate closes behind you, when you go to the dungeon, shut your frickin' mouth. Shut your fricking mouth. Shut up or you're gonna die. They're gonna kill you in there, Jack. They're gonna kill you. There's no rules to what they can do to you once you're behind the dungeon doors. You shut your frickin' mouth. You don't make friends with anybody. You don't talk to anybody. You don't say anything. You shut up. Then when they put you in the dungeon with the other people that they've treated like animals for weeks, months, or even years, you rip out as many push-ups as you can. You just do push-ups and pull-ups and squats, and you pump yourself up, and you don't say a frickin' word to a single person there. You have nothing to say. That's not your place. You're not staying there. Why do you care about the politics? Shut up. I'm telling you, I've been to the dungeon dozens of times. It's horrible. Each and every one is dangerous. Each and every one, your life is on the line. You got to listen to me. It's one thing that I tell you to plead the Fifth out here. It's another thing. I mean, you'll die. They'll kill you. They'll absolutely kill you. They'll kill you. You resisted them. They were keeping order. Yeah, it was horrible. You know, we told him to settle down and he didn't. And then the guards ran out there and grabbed him and he slipped and he hit his head on the back of the ground and he died. That's it. That's the whole story. The cameras in that block weren't working. He hung himself just like Jeffrey Epstein.
Where that's a Supreme Court case from 2018. The officers come up to this wild party. The place is a mess, and there's under the Heibel exception, it's not a lawful order. So you don't have to. A subject doesn't have to follow an unlawful order. Only a lawful order.
Right.
There's also this whole issue of the Wesby case, where that's a Supreme Court case from 2018. The Officer Wesby case. There's also this whole issue of the Wesby case.
The Wesby case.
Where that's a Supreme Court case from 2018. The officers come up to this wild party. The place is a mess, and there's nudity, drug use. They got somebody on the phone who claims to be the landlord and admits she isn't. And they said, "Oh, that's enough evasive behavior. That's enough." But I am suggesting to the...
Did you hear that? That's enough evasive behavior. What are we talking about here? What are we talking about? A total police state. That's what we're talking about. If you don't follow the directions of police, you're evasive. I just almost shot snot out of my nose. What are we talking about here? This is not America. I'm going to teach you guys this next week, Constitutional Law Scholar. It's on the wall, baby. I can't wait for you guys to learn the real foundations and principles of liberty.
This court, my client didn't stumble. The officer admitted that there was no resisting. He admitted he wasn't, quote, on something. And if you watch the video, the guy's stone cold sober. And that's what we allege, and the video is part of the complaint because it's referenced. So my assertion is that the evasive behavior simply doesn't get, in this case, under that case law, to where it needs to be for Officer Schmitt to arrest Mr. Schmitt. Mr. Murphy, sorry.
Schmitt can't arrest Schmitt.
What about the clearly established problem?
Okay.
Is there enough ambiguity in Heibel and these other cases to say that it wasn't clearly established that he could ask for his identification, assuming it was only a Terry stop?
Yes, sir.
If you guys don't notice, almost every single thing that happens in policing, the word Terry stop comes right next to it. Every time I play some court stuff for you and I show you guys how the courts are stripping us of our rights over and over and over, what does it always come down to? Terry, or a case that's an extension or jurisprudence of Terry versus Ohio.
The established problem.
Okay.
Is that,
Schmitt to arrest Mr. Schmitt.
Listen,
Mr. Murphy, sorry.
what about the clearly established prong?
okay. What about the clearly established prong? Let's take a look at what the clearly established prong is. Let me see what you let me see what you guys can see. Let me open this bad chicken big. Okay. What is the clearly established prong? The clearly established prong in law typically refers to the requirements in the context of qualified immunity, a legal doctrine in the United States that shields government officials, including law enforcement officers, from being held personally liable for actions they take in the course of their official duties. To successfully sue a government official for violation of a constitutional right, a plaintiff often needs to show two prongs. Forgive me. One, a violation of a constitutional right. The plaintiff must first demonstrate that the government official violated a clearly established constitutional right. Like I told you, plead the Fifth Amendment and you go to court. He clearly continued to question you after you said, I plead the Fifth. This means showing the official's actions violated a right that is recognized and well established in existing law. This prong requires the plaintiff to point to prior case decisions or legal precedent that clearly established the constitutional right in question. Your Fifth Amendment is clearly established since 1791. Clearly established law. This is the second prong. Clearly established law. The second prong, which you mentioned as clearly established, the second prong, which you mentioned as the clearly established prong, requires that the law regarding the violated right was clearly established at the time of the alleged violation. In other words, the plaintiff must show that a reasonable government official in the same circumstances would have known that their actions violated a clearly established constitutional right. This often involves demonstrating that there were prior court decisions or legal standards in place that would have put the official on notice that their actions were unconstitutional. The clearly established prong is crucial because it serves as a barrier to holding government officials personally liable for actions they took in their official capacity. If the law regarding the asserted right was not clearly established at the time of the alleged violation, qualified immunity may apply. And the official may not be held personally liable, even if a constitutional violation occurred. Oh, God. Oh, my God. It's critical because it serves as a barrier. It's critical because it serves as a barrier to holding government officials personally liable for actions they took in their official capacity. If the law regarding the asserted right was not clearly established at the time of the alleged violation, if the law regarding the asserted right that was being violated was not clearly established at the time of the alleged violation, you have to plead the Fifth Amendment out loud and unequivocally, because if the law regarding the asserted right, your fifth, so let me read it again, and I'm going to put it in the proper verbiage so you can understand the sentence. If the law regarding the Fifth Amendment is clearly established at the time of the alleged violation of your constitutional rights, and even if the law regarding the asserted right is, if it's not clearly established, if you don't clearly say, I revoke consent, stop searching my car, if you don't clearly say, I plead the Fifth Amendment to remain silent, if you're suing with the two-prong effect, the two established, what is clearly established prong. So if you're suing on the clearly, you have to be clear that you asserted your right. That's why it's so important that you narrate everything. You have to assert the right that you're going to sue for at the time of the alleged constitutional violation. So if it's not clearly established that why you think your rights are being violated, then qualified immunity could still apply. So if News Now, I want to see you guys. If News Now Ninja decides that he's going to go film in a police department and he's going to be the press, he's going into the police department to film the police department, to audit it as a member of the press. If they arrest him and he has not clearly established and announced, I'm acting as a journalist, as a member of the press, then because the clearly established prong, he may not be able to sue. And the federal judge brought it up. What about the clear? What a basket. And so the official, if you don't announce what you're going to sue for, he may not be held personally liable, even if the constitutional violation occurred. Qualified immunity has been a subject to debate and controversy in the United States, as some argue that it can be difficult for individuals to seek redress for alleged violations of their rights by government officials. Courts, including the U.S. Supreme Court, have issued various rulings over the years clarifying the standards for qualified immunity and how it applies to specific cases. So, wow. I mean, to me, welcome to Constitutional Law Scholar. This is, you're learning the two-prong standard here. You're learning these things, and this is how you can become a scholar of your own, just by taking these little pieces of information and stacking them up for years and years and years and years. And then you'll be able to film police and feel a lot more confident, because now you know that when you go film them, you say, I'm protesting police and I'm using my First Amendment right of press and speech while I'm here, because I may even curse this cop out if he triggers me, because I can't stand watching tyranny. So I have the right to curse you out, and I will frickin' curse you out. It's just that simple. I have the right to curse you out. So you can say that. This is the gold that just keeps on giving.
Okay.
Is there enough ambiguity in Highball and these other cases to say that it wasn't clearly established that he could ask for his identification, assuming it was only a Terry stop?
Yes, sir. And that's why I read you directly from Hybel. Hybel says, under these principles, an officer may not arrest a suspect for failure to identify himself if the request for identification is not reasonably related to the circumstances. That's pretty strong.
Who makes the decision as to what's reasonably related?
Sure.
And
Who does it? Who makes the decision?
We talk a lot about in qualified immunity, it can't be at a generalized level. It has to be some specificity. How do we make that determination, or who makes that determination? What's reasonable?
The cop does.
related?
Well, I think I view qualified immunity as sort of a large cloud of complexity, but I think that you have to look at where the case falls on the continuum. In other words, is it way at one end or way at the other? In this case, this idea that the officer had the subject, Mr. Murphy, right in front of him, tells him that identification of who did it is not part of his investigation. He knows who did it. It's the human being right in front of him.
Walking on.
Your rebuttal time has started, if you'd like to reserve.
So he's guilty of walking on the wrong side of the road. He's guilty. They created a racist statute in 1965 to arrest black people for walking on the wrong side of the road. And then once that black person was in jail, they would rot because they arrested people they didn't like. Oh, there are some blacks that the cops were, oh, Jimmy, he's okay. But if you were one of the blacks they didn't like and you walked on the wrong side of the road, you got arrested. And you can beat the rap, but not the ride. Now the ride includes the torture cuffs, which are just horrendous, right? But just imagine what the ride was like in 1965. It doesn't matter what color you are. Just think about that. Imagine what the ride was like in 1965 if you were, well, I guess back then, unless the cops really hated you and you were white, it was a much more civilized system for whites. Much more civilized system for whites. I mean, jail's still dog poo, but you remember the old TV shows where they'd show them in jail and the sheriff would be sitting in there and the sheriff's wife would come in, she'd bring in some pie, and they'd be like, "What'd Andy do?" "Oh, he was drunk last night and acted like an idiot," right? I mean, those TV shows now, when you reflect back on them, you really like, I can't even remember, Mayberry and what was that? What was the really famous one? The sheriff, anyway, his son and Hobie or whatever. No, I'm thinking of Baywatch. Anyway, those TV shows back then that showed the cops and how they would give you some pie or some, the missus made some cobbler last night. Do you want some of this? Like those illusions that they gave the general public, that if you got arrested, the sheriff was just sitting over there. Remember the ring of keys they had, and they could hook the keys. And so then, of course, if they sold it to the people, that they could just throw a line over there and steal the keys, when then they have to up the security of those prisons. And they just fed the American people a narrative and a lie that just isn't true. That's why that saying, "you back the blue until it happens to you," is so relevant, because you have this idea of what the process is like when you're going to get arrested and go to jail. Unless you've been arrested and go to jail, you have no idea. You couldn't even fathom how poorly you're treated. You can't even imagine it. It is the worst treatment. And when you see other human beings who have eyes and 10 fingers and ears and noses and mouths, and you see how they treat you for the very first time, when they treat you like you're not a human, when you tell them these cuffs are tight, they hurt, and they go, "I can get a finger through there." Dude, you will back the blue until that happens to you. And then when it happens to you once, even if you're the most understanding person ever, the way the factory, the system is inside of the dungeon, my friend, when you get acquainted with that, you're gonna find out why there's so many people who back up what we do. It's horrible. You'll back the blue and then you'll come here and you'll figure out that I've been right the whole time. The system sucks and it has to change. You can't join it and make it better. You have to go over top of it, take power of it, and change it.
See that, I'll stop. Thank you so much.
Now listen to the lawyer for the state.
Mr. Jordan.
This is you're gonna want to puke. I've already heard this.
May it please the court. I am Wayne Jordan here on behalf of Appellee Officer Michael Schmitt, requesting this court uphold the district court's granting his motion to dismiss appellant's retaliatory arrest claim. The heart of the matter today is that appellant fails to plead that Officer Schmitt violated any clearly established right as required by the case law to overcome the qualified immunity protections. As we just heard, that he does have the burden of proof today in establishing that the right that his client had, that the right that Officer Schmitt violated was clearly established. When we look at this in the case law, clearly established as directed by Westby, says that to be clearly established, a legal principle must have to be a sufficiently clear foundation by then existing precedent. The rule must be settled law, which means that it is directed by controlling authority, and that there is some robust case law to understand this.
How about the Supreme Court of the United States? Doesn't your argument require us to ignore the Neves decision?
I don't believe so, Your Honor. When we
Because that was just dicta.
look at the Neves exception, it is, as he just admitted, it is dicta. It is something that is suggested. It is a hypothetical, and that it is not the controlling case. The controlling facts of the matter in Nivens would actually favor Officer Schmitt. There is some low-level conduct that is occurring. There is then after the officer.
The low-level conduct is that they stopped him on the side of the road. He's walking down the side of the road. And then it sounds from the testimony that Mason Murphy tore into his booty, that he ripped him up one side and down the other for 9 minutes straight, and the cop arrested him. That's what it sounds like.
There is some low-level conduct that is occurring. There is then after the officer then pursues that conduct, there is some we then get into the protected right that the appellant alleges, and that the court then found that no, they are arresting them based on the actual criminal conduct, and that the rest of that is ancillary.
What criminal conduct? You're arresting someone for walking down the road. That's what he got arrested for. Atwater versus City of Lago Vista, 2001, has got to be changed. It's got to be overturned. It's got to be legislated. And it can be by executive order in a state that you cannot reasonably arrest somebody for a misdemeanor crime. It's not reasonable to arrest somebody for a misdemeanor crime, a misdemeanor infraction. I don't even want to call it a crime, because walking down the road should not be illegal.
We look at the protected conduct that is carved out as what we would consider this narrow exception. The fact pattern would not even direct the circumstances here in this case.
Well, is it fair to say the arrest was based on the failure to identify, not the initial stop? I mean, that seems fairly clear from the record, right? In other words, not from him walking on the wrong side of the road. It looks like when you look at the record, the arrest was squarely based on the failure to identify here. Is that the way you view it? I mean, that's the way I think the district court viewed it.
And I would not disagree with the district court in that assessment, that there is at least I would say the primary focus here is that it's the failure to comply with a lawful order. And that does incorporate not in identifying himself. But there is, when we look at the lawful order and the initial crime that is committed, and we will again admit that walking on the wrong side of the road is why the officer stopped him. It is a lower level crime, but that is what instigated.
Listen to that. Does this make you cringe? Listen to this.
That the lawful order and the initial crime that is committed, and we will again admit that walking on the wrong side of the road is why the officer stopped him. It is a lower level crime, but that is what instigated the fact pattern here. When taking those together, Westby is controlling on that, Your Honor, and that
the fact pattern,
the evasive procedures the evasive tactics that Mr. Murphy used, coupled together with the initial illegal conduct, does give rise to a common sense or a common law inference that some other criminal activity is going on. As appellant cites to the YouTube video, I believe that is part of the record, and many have reviewed it at this point, that there is at least some suggestion that
I'm sorry, there is a YouTube video. Find it.
To the YouTube video, some other criminal activity is going on. As appellant cites to the YouTube video.
I'm going to pause for 1 second. Have to find that video. I'm not going to stop the whole thing, but we have to find that video. He said a YouTube video. Where is it? Where's the YouTube video?
To a common sense or a common law inference that some other criminal activity is going on. As appellant cites to the YouTube video, I believe that is part of the record, and many have reviewed it at this point, that there is
a lot of people have seen it, but we haven't seen it. God bless it.
There's at least some suggestion that something else is going on, that other criminal activity is at least at the bare minimum.
You seem to be asserting that the refusal to identify oneself creates probable cause for an arrest. Does the case law support that?
Coupled with the totality of circumstances, Your Honor. And I would not say that simply it does give rise to.
So the totality of circumstances is going to come from the 1980 case of Cortez versus United States, which is an extension or jurisprudence based on the foothold in the 1968 case called Terry versus Ohio. The totality of circumstances that he just cited right there, it's going to get locked in stone.
just probable cause. Shepard versus Ryanberger would dispel that. But it also is not
Unless we overturn Terry, and then it's over. Then there's no more. Well, you take the totality of circumstances. He's walking down the road and there's a robbery in the area. Well, totality of circumstances.
coupled with the totality of circumstances, Your Honor. And I would not say that simply it does give rise to just probable cause. Shepard versus Ryanberger would dispel that. But it also
Shepard versus Ryanberger. See if that's. Let me dump that in the chat. I don't know if I don't have my glasses on. I don't know if I spelled it correct. I don't have a spell check. Someone find that case too.
is not clearly an unlawful act. And that is
Put those in the private comments, Colin, and I'll look in the private chat on this thing.
Your Honor. And I would not say that simply it does give rise to just probable cause. Shepard versus Ryanberger would dispel that. But it also is not clearly an unlawful act. And that is what appellant must show, is that the conduct that Officer Schmitt engaged in is clearly unlawful, so that every reasonable officer would know that his actions are unlawful, and that is the standard to defeat qualified immunity protections.
Counsel, what troubles me about this case is that we are at the pleading stage. This is not summary judgment. We're under a plausibility standard here.
Your Honor,
So he's suing before the criminal case has gone.
the case law on that I would direct towards Hess, which says that again, they do have the burden to show that there is going to be something. It's not going to just be merely consistent with that they have the right to a cause of action. They must at least be able to meet all of the elements. And as as appellant agrees, the heart of the issue today is going to be part 4 for pleading retaliatory arrest, and part 3 that he fails to even do that. And when we look at the case law, I mean, there really is
Well, what's he missing?
he is missing the 4th element for retaliatory arrest, that he lacked probable cause or argued probable cause, and that
So you're asking us to ignore the Neves case then?
I'm not asking to ignore the Nivens exception or the dicta in Nivens that carves out some very narrow exception. The argument here is that it still doesn't apply. The Nivens
He
exception.
just has to plead a plausible claim.
Correct, Your Honor. And that in the Nivens exception, it is going to be heavily fact intensive for what the court is considering. That someone is
Listen to this again. Did you hear this?
dicta in Nivens.
So, I mean, the judge asks him this is the next level. The next level is the Supreme Court. After this court, it's the Supreme Court. So
Or argued probable cause. And that
So you're asking us to ignore the Neves case then?
Neves, Nevins, everybody calling it something different. But here's the point. The dicta that Neil Gorsuch said in the Neves case, this judge who's one level below the Supreme Court is saying you're ignoring what the judge said up there. So what the judge said is dicta. He said that we have to carve out an exception for jaywalking. And so he's now applying jaywalking to him walking down the side of the road. The original lawyer for Mason Murphy convinced the judge, you just heard it happen, that he's listening to the lawyer saying jaywalking and him walking on the side of the road are the same thing. So you just heard that lawyer's argument was effective and it worked. And now he's asking for the defense lawyer for Michael Schmitt if whether they're supposed to ignore what Neil Gorsuch said, that you're supposed to be able to carve out an exception.
I'm not asking to ignore the Nivens exception or the dicta in Nivens that carves out some very narrow exception. The argument here is that it still doesn't apply. The Nivens
He
exception.
just has to plead a plausible claim.
Correct, Your Honor. And that in the Nivens exception, it is going to be heavily fact intensive for what the court is considering. That someone is first engaging in a protected activity such as their First Amendment rights, and then after this, subsequently, they are arrested for something low level as jaywalking. As appellant argues and that the Nivens exception applies, He really wants to misdirect the court that walking on the same side of the road is the same as jaywalking. That's not where the exception comes in. It comes into the factual scenarios, and he pleads himself out of court.
So going back to that issue, what specific facts here lead to probable cause?
The specific facts here that lead to probable cause, first, and this is from his petition and the brief, that while on duty, Officer Schmitt observed Murphy walking on the wrong side of the road at night or partial darkness, and then...
It's a racist law created in August of 1965 to be able to arrest blacks for walking down the road because blacks didn't have cars.
Setting that aside, I mean, I think you conceded earlier the arrest is basically based on the interaction that happens after the initial encounter. The failure to identify, and I think you said that the totality of circumstances would lead an officer to suspect something else was going on. So what specifically, in addition to the failure to identify, would lead a reasonable officer to be suspicious here to the level of probable cause?
If I'm understanding you correctly, Your Honor, then it is the facts that get towards that give rise to even having the failure to identify or giving that lawful arrest, you can see that they are the same, start with the entire reason why he stopped him, why he pulled him over. He didn't just pull him over because he thought that he was exercising some protected right. And because he is not pulling him over for exercising a protected right, that is the heart of why the Nivens exception cannot apply here. It is fact intensive, and so the only reason that he gives him he even gives him the lawful order, which again, to get out of that, we are having to do mental gymnastics to try and figure out, is this an unlawful order? That's the heart of the matter today, Your Honor. He did not clearly give him an unlawful order. He did not.
Yeah, they created a law that it's illegal to walk down the wrong side of the road.
Clearly just come after Mr. Murphy for exercising some protected right as suggested in Nivens. He didn't know who he was. He saw someone violating the law.
I guarantee you Mason Murphy is black.
Again, low level, but
Let's find out. Let's find out. Let's switch gears here real quick. And News Now Ninja sent me the video, and let's take a look at the video right now. 1 second. Let me switch over here. We're going to take a break from this video, and we're going to watch. Got you, News Now. I got your text message. Thank you. I'm not going to say anything else. It was on my other phone. I have another phone. And so I appreciate that. Thank you, dude. So let's take a look. Is he black?
If we suspect a crime has been committed, will be committed.
He's going to list off a Terry stop right at the beginning of this. Do you hear that? It's a Terry stop. He's listing Terry.
If we suspect a crime has been committed, will be committed, or is being committed, we can lawfully identify you. And he believes there's crime. So
that is not what Terry versus Ohio says at all. He's white. Black laws now being applied to white kids. He's a kid. He's young.
Can lawfully detain you. So go ahead, officer. You do what you need to do.
What crime? When I asked you to vacate the scene while I talked to him, you refused. Why would you do that?
Is he on your PA system?
So he's now statching Missouri. He's now quoting Missouri Code 300.080 that it's illegal to ignore the directions of a peace officer.
When I asked you to vacate the scene while I talked to him, you refused. Why would you do that?
Is he on your PA system?
Probably.
I got him. I'll deal with him.
He was walking down the street. That's not illegal.
You failure to identify to me, you're going to sit there, I'm going to make you fingerprint, and it takes about 3 months for me to get fingerprints back to find out who you are, and I will make him sit there the whole entire 3 months.
You got a supervisor? You got somebody above you? In here, you're not going to run your mouth to me, because I'll just assume punch you on your face and then put you in that chair.
What did I tell you? What did I tell you? I don't care how mad you are when you go behind the dungeon walls, shut up. I can't be more direct with you. Shut up. When you're behind the dungeon walls, there's no more rules. There's places in the dungeon they can take you where they will do it, or they'll have someone in the jail do it. And it won't, I'm tough as nails. I got one good fight in me. I'm going to be broken because I'm too old to fight. My body's going to break, but I got one good fight in me against one guy. I don't against 3 guys cornered in a brick wall. Neither do you. Shut up. Shut up. They'll have you go take a shower. Go to the showers. You need to clean up. You think I'm kidding? You think I'm joking? I'm not joking at all. You can, I almost get like, I feel personally like I get really unlikable. I feel like I get like I become an unlikable character when I really want to just tell you, you know, if you don't freaking listen to me, you are going to have the worst time in the dungeon. It'll be worse if you say a freaking word to those people. I have status with hundreds of thousands of people and millions of people who watch the videos. We have a team, a core team of Team DLZ. I have that. If they take me, there's going to be hundreds of phone calls. You don't have that. Shut up behind the dungeon walls. Shut your frickin' mouth. I mean it. I don't care how bad the cuffs hurt. Shut up. If the cuffs hurt after 20 or 30 minutes, politely say, "Officer, will you please loosen these cuffs a little bit?" And then shut up. Don't beg. Don't beg. Don't beg. Don't beg. You may have asked too soon. You may have requested too soon. You have to show that you are a submissive little before you just got to be, you got to just be so careful. You got to listen to me. I'm telling you, I've been to the dungeon a lot and I know the rules.
Punch me in my face. Absolutely. Would you like to do it? That's what you'll do? Absolutely. We're going to be Are you? Are you going to influence alcohol or drugs? Are you? Are you suicidal? Are you?
Welcome back to the Lackluster channel. Today's story was submitted by a viewer named Mason, who was walking down the street and pulled over in Missouri. Officer Schmitt of the Sunrise Beach Police Department noticed him and pulled over to, quote, check his safety. The CAD report claims that Mason was possibly intoxicated, with Officer Schmitt later stating that he was stumbling down the road. Note that Mason is only 20 years old and does not consume alcoholic beverages or narcotics, and was not under the influence. Sunrise Beach PD is refusing to release Officer Schmitt's body cam footage, but while on scene, he requested backup, and Officer Shoemate of the Lorry Police Department arrived on scene about 6 minutes later, activating his body cam a minute and a half after his arrival.
Are you intoxicated?
No.
You got the smell of odor on you, okay? You committed a crime. In the state of Missouri, in the state of Missouri, time out. Okay, this is how this is going to go. If we suspect a crime has been committed, will be committed, or is being committed, we can lawfully identify you. And he believes there's crime, so we can lawfully detain you. So go ahead, officer. You do what you need to do.
What crime? What crime has been committed?
Don't pull away from him.
Well, I'm not. What crime has been committed? What's your name and badge number? What is your name?
And she said you were in a silver car.
You have to identify yourself.
Yeah, she's in a silver car.
What?
Wow, he's being kidnapped and they won't tell them his name. They won't identify themselves.
Run up there and see if you can
What's
find
your
her.
name and badge number? Yo, you have to identify yourself.
Mason is taken into custody, and while Officer Shoemate is accurate with his definition of reasonable suspicion, his articulation of his suspicion leaves something to be desired. The video starts with the officer stating that Mason has, quote, the smell of odor.
You got the smell of odor on you, okay?
We can reasonably assume that he meant Mason smelled like alcohol, an assumption that is contradicted by both officers later in this video, as they both admit neither of them smelled anything.
I didn't ever get close enough there.
The current reason for Mason's arrest is failure to ID, which is a secondary charge if a suspect refuses to identify after having been lawfully arrested. But with the officers both admitting that neither suspect him of being intoxicated, arresting Mason for not providing his name is a blatant violation of his Fourth Amendment rights. Mason's girlfriend was at the scene prior to the body cam footage starting and was told to leave, and now that Mason has been cuffed and detained in Officer Schmidt's vehicle, they convoy to her vehicle up the road.
So, you know, this is the whole reason why This is the whole reason why I've created the Fifth Amendment card. I have a card now that goes in your wallet. I can show it to you. The draft is done. It's just about to be finalized. I have a Fifth Amendment card that goes in your wallet. And when you get them, you get 2 of them. You don't get 1, you get 2. You get 1 for you, and you get 1 for the cop. And you give the 1 to the cop. It's the same size as your ID. It goes right next to your wallet. And you have 2 cards. And the cop stops you. He says, give me some ID. You open up your wallet, and you give him that Fifth Amendment card. And you say, I plead the Fifth Amendment. And then if he says, you have to ID, it's numbered. If you're sober and normal, you just read it. Number 4, unless there's probable cause to arrest me, I don't have to ID. Hibble versus United States. I must identify. Identify as good citizen. It says right there. He sees the same card you're reading. He can't question you any further. You know it from the clearly established clause that you've asserted your Fifth Amendment right, and that he should know that your Fifth Amendment right is constitutional. So, listen, if you guys don't have my trifold, you should have my trifold. It goes up here in your visor. Cop pulls you over. You got this like this. You slip him your ID, your registration, proof of insurance. You've got to have the trifold in your car. You have to have it. You have got to have it. Because right on the trifold, it says right away, I'm sorry, I don't have one. I gave the last one away. I ordered more. I gave away like a dozen in like 3 weeks, I guess. 3 weeks. I gave away a dozen. Because as soon as I meet people, especially when I meet tall, big black guys, unfortunately for me, the statistics that I know, I almost always have to give a gigantic black guy my trifold. And then I literally annoy the guy with, you have got to listen to me. You got to hear me. The old way was, why did you pull me over? No, my ninja. Not for you. I might be able to get away with that a little bit, even if I'm just John Q. Citizen and I don't know my rights. Hey, why'd you pull me over? If I'm really amicable and nice, hey, officer, how are you? Was there a problem back there? Yeah, you were speeding. Oh, I thought I was doing the speed limit. Oh, I'm sorry, officer. Here's my license, registration, and proof of insurance. Okay, Mr. DeCastro. I can get away with that. I'm white-skinned with green eyes. Maybe the next time I get pulled over, I'll try one of the Johnny Good guys. Oh, hello, officer. Is there a problem? Could you guys see me doing that? That would just be. All right. I'm sorry. I didn't mean to interrupt. Let's get back to what they do to Mason.
How are you? Doing well. Got an officer that's going to come talk to you, okay?
Okay, what?
A couple different things, okay? Disobeying a lawful order, okay? If he tells you to move on, that means move on, okay?
I did.
Which is illegal. He said he told you a couple times. So I'm going to have this officer come talk to you, and we'll determine what's going on from there, okay?
I just came to the side of the road because that's my boyfriend. Just wanted to see what was going on.
Now, when I asked you to vacate the scene,
Tesh Lines versus Danforth. She has every right to stop where it's safe for her to stop.
while I talked to him, he refused. Why would you do that?
Is he on your PA system?
Probably.
I'll get him. I got him. I'll deal with him.
I'll deal with him. He's a public servant. He's supposed to serve the public. Instead, he's a jackboot thug pig. Put that in the comment section. JBTP.
What's your name, man?
Officer Schmitt, Ward PD. Yep.
What's your
Hold on 1 second. 3:30.
Could you just imagine yourself, though? You're walking down the road and they come up and demand your ID and then arrest you? That's crazy.
You wicked area. 330, brother.
These guys are tyrants. What a pig. I mean, really, what a pig. They're actually going to arrest him. That's crazy, for walking down the road. And they didn't even know what they were arresting him for to begin with. That's why the case we're listening to right now, they say you don't have to have probable cause. You can just arrest him. Find out later.
What's your ID?
I don't have my ID.
Okay, well, you give me your info.
On my person.
Social. You have a pen?
Social security number. They want her social security number.
Taylor, Sem, SEMB,
I'd love to talk to her.
SEMD?
MB. He was walking down the street. That's not illegal.
Despite the fact that Taylor was blocks away at this point, they are asking her for her ID for failing to move on.
So here's a little bit of word of advice.
That's a violation of Missouri statute 300.080. You have to comply to the directions of a peace officer.
For you, and when he gets out, because he's being a lot nicer than I would in this situation. Okay, you failure to identify to me, you're gonna sit there. I'm gonna make you fingerprint, and it takes about 3 months for me to get fingerprints back to find out who you are, and I will make him sit there the whole entire 3 months. Okay, for one, if that officer believes he's been drinking and he's walking down the road, it is actually a crime. It's public intoxication, and it's a safety of himself. I'm just telling you right now. Okay.
I know what
Okay.
public intoxication is.
It is a crime. Okay, if he believes there's crime being committed, has been committed, or will be committed, he
Terry?
has the right to identify anybody in the state of Missouri. Okay.
No.
And if that officer believes so, he has full identification. With him failure to do
No.
that, if it was me,
No.
your boyfriend would be sitting in jail till I get his fingerprints back in 3 months.
So I'm so happy this is happening. I'm not happy this is happening. I'm so happy this is happening that we all get to see and hear how they've been treating people for years and years and years. And to the black community, they've known this for a really long time. You find an old black guy, he hates cops. He saw the beatings. He was there. You know, when you could just do whatever the hell you wanted, there was no cameras back in the 80s. They hate them. They hate them as much as the people in this room hate cops. Now, when people say I'm mean to cops, just remember that almost every cop, because power is this drug, it's intoxicating, just takes you over. This is why we have such crappy leaders. They're not leaders, they're elitists. I'm going to lose myself here. Let's go back to the tyranny this guy's doing.
Mason has still not identified himself, and it sounds as though Officer Schmitt said that he would use his perceived power to jail him for up to 3 months while waiting to identify him if he were the arresting officer, claiming that if an officer believed that Mason was intoxicated, that it's a crime. In a moment, both officers admit that they do not smell alcohol, and do neither field sobriety tests or blood alcohol tests to verify whether or not they could arrest him for public intoxication. However, Revised Statute of Missouri 67.305 explicitly states that counties or cities are not to arrest or punish for public intoxication. Dealing with an intoxicated subject is further outlined in 67.315. It states that a person who appears to be intoxicated may be taken by a peace officer to the person's residence, treatment service, or jail for custody not to exceed 12 hours. Of course, the statute also grants officers immunity from prosecution for false arrest if the officer has reasonable grounds to believe the person is intoxicated. So at this point, the only question is whether the officers reasonably believe that Mason is intoxicated and what grounds they make for their claim. Let's hear from the officers themselves.
I didn't ever get close enough to him. I can go talk to him though if you want. See if I can get him to calm down a little bit. But that's up to
He was
you.
stumbling, I could have found him, but I don't smell anything.
Both officers have now admitted on video that neither of them have reasonable grounds to hold Mason for public intoxication other than Officer Schmitt, claiming that he stumbled a little bit while walking down the side of a dark, windy road in the middle of Ozarks in sandals. Taylor is released, and Mason is transported to Camden County Jail for public intoxication and failure to ID. The audio is difficult to pick up, but I have done my best to caption important parts. Note that Mason has still not identified himself.
I'd explain to him first what would happen if he don't comply. The 3 months sitting in jail.
You listen to me talk. Listen to me.
What'd he do?
You guys are
Just run his mouth.
Okay. That'll work.
What crime did I commit? Did you tell me what crime I committed? I told you. You didn't? No. Okay, well, what? Shut your mouth and listen, you know by now. All right, I'm sorry. What crime did I commit? What did I do? You can't tell me? You're going to stand up so you can... Yeah, sure. Yeah, okay. I'm going to pull one you now, okay?
Mason's personal belongings are taken and stowed in this box. This paper was released through a public records request. It is a 12-hour hold form with revised statute 67.3.
12-hour hold form. You can be held for 12 hours on a 12-hour hold form.
315 is a header. The officer's reasonable
Officer granted immunity from legal action when a person appears to be incapacitated or intoxicated may be taken by a peace officer to the person's residence, to any available treatment center, or to any other appropriate
grounds for the public intoxication 12-hour hold is, quote, refused to identify, walking down highway while possibly intoxicated. At this
Wow. So they're holding him for 12 hours because he's possibly intoxicated. And the cop's immune from anything he does.
is a 12-hour hold form with revised statute 67.315 as a header. The officer's reasonable grounds for the public intoxication 12-hour hold is, quote, refused to identify, walking down highway while possibly intoxicated. At this point, there is still walking.
That's in an actual report. Why possibly intoxicated, but he wasn't.
Down highway while possibly intoxicated. At this point, there is still absolutely no evidence to substantiate the claim of the officer, and like a good patriot, Mason has still refused to identify.
You got a supervisor? You got somebody above you? Okay. Can I ask you a question? What do you need to force somebody to identify themselves? What are you talking about? So like, say I'm walking on the side of the road. Anything that happens to you out there with them, like, no, I understand. I'm asking you a question. You're a cop. How long are you? You're not. What are you? Oh, okay. What am I even talking to you? You know, you're right there. We don't know. You asked me. Well, you should have identified yourself. Really? You want to start off with it, right? What did you say? I start off with it, right quick. You know, I'm not playing your little bullshit game. I'm not playing any fucking game. You can throw a game if you want to. In here, you're not going to run your mouth to me, because I'll just assume punch you on your face and put you next year. You'll punch me in my face. Absolutely. Would you like to see me do it? That's what you'll do? Absolutely. You keep running your mouth to me? Is this all? There's 15 cameras in here, and they all have audio. And you're threatening to punch me? Absolutely. Absolutely. Why? Because I can do that. You can't.
Yes.
I just did it, right?
That's normal. This is normal.
Are you going to identify yourself with this officer or not? Well, if I do, then what happens? I don't know. What do you got on? What does he have on? I'll explain to you again. I'm going to tell you if you or shut up. Well, no, I don't need to shut up.
Oh my God. Did you just hear it?
What do you got on? What does he have on?
What does he have on me? And then they tell him to shut up.
I'll explain to you again. I'm going to tell you if you or shut up. Well, no, I don't need to shut up. Go ahead and put him on 12. When you want 12. Yeah, that's fine. Okay. Please go ahead.
You heard that right. This coward, Jerry Pedigo, is not only believed to be the supervisor of the Camden County Jail, he also operates the facility with impunity and disregard for the safety of his inmates, as he threatens to attack Mason for asking questions related to his detention. State official. Citizen. Asks a question. Threatens with violence. Knows he's on audio and visual recording. If that isn't an egregious violation of Mason's First Amendment rights and a disgrace to the authority bestowed upon this official, I don't know what is. Imagine if the cameras weren't there. Note that Mason has still not identified.
I'll sit here indefinitely until I get my fingerprint. You think that's how that works? We won't put on here. John Doe? So you already say your name reduction? Huh? You already tell your name reduction? Well, if I do, am I free to go? Yes, you can. And we did get right. I already brought you down here, so we'll get free. So what happens after I'm free to go? If we want to have it after, what's it done? So you did all this because what?
They did all of this because they believe they can get away with it. Here, Officer Schmitt tells Mason that if he identifies, he would be free to go, proving that the officer had no reason to believe that Mason was intoxicated, and that the 12-hour hold was retaliation for flexing his Fourth Amendment right to be secure in his person, papers, and effects.
What's your first name? Spell it correctly on the plate one, right? What's your, oh, I won't be making it. So, it is shoot. So I'm going to be making it first, so.
Threats?
No, I'm not threatening you. If I was threatening you, then you would know. Okay. I don't make threats, Joe. I don't make threats. All right. What's your date of birth? What's your date of birth? You have any money on you right now? Yeah, I do. How much? I don't know. You can count it if you want. All right. Are you on anything? Are you? Okay. Are you over here? Are you? Are you under the influence of alcohol or drugs? Are you? Are you suicidal? Are you?
The officer eventually claims that Mason was walking on the wrong side of the road almost an hour after making contact. However, no charges were filed, and Mason was set free after about an hour and a half in a cell. Mason was locked up at 10:01 p.m. and had still not identified. The CAD report shows that just 5 minutes after being locked in his cell, that his name was entered into the system. It is likely that the officers found his ID and his personal effects, taken from him earlier in the video, which I have obviously edited, but luckily you can see the full version, or at least what the departments involved have elected to release to us, in the links below. The officers claim that this was all for his safety.
Now we saw the video, and now you guys know it went to court and Mason lost. It went to federal court and Mason lost at federal court. You guys just saw the video. You guys, I mean, you saw that guy's presentation of that body cam and all that stuff. We can find the links another time. We can look at it, but you guys just saw it. You guys just saw the video. And then the court said, that's okay. They can arrest him without any probable cause for walking down the street. And then after the fact say, oh, look, we found probable cause. He was walking on the wrong side of the road, created for blacks in 1965. That's why I put this, before I did this talk with you guys, and, only like 5,000 or 10,000 people will see this, but for the 5,000 or 10,000 people who see this, this is probably one of the most informative and educational videos that we've ever made, where you can, the good part was that we went through the court case first, and then we saw Mason's story as it was presented. And so now we have a picture, and now you guys know that Mason just lost, that he just lost at federal court. His next step is certiorari to the Supreme Court. And there was so much to learn on this particular live stream. And I'm just so grateful that we got to go over every bit of this. And that's where we are. They ruled against him.